Good morning, everyone. My pleasure to introduce our presenters today. First off, Ken Schumacher, partner at Murphy Austin. Ken's practice focuses on all aspects of construction law, which includes representation of contractors, developers, owners, subcontractors, and design professionals on both the public and private project side. Ken's construction practice includes contract drafting, negotiation, licensing issues, bid protests, in-project consultation, and focused representation and counseling of clients through mediation, litigation, and arbitration at both the state and federal level. Ken received his JD from Boston University School of Law in 1995. While in law school, he served as an articles and book review editor for the Boston University Public Interest Law Journal. And Ken graduated from University of California, Berkeley in 1992 with a bachelor's degree in both history and political science. Joining Ken for the first part of the presentation is Scott Alexander, also a partner at Murphy Austin. In fact, Scott actually served as the managing partner for Murphy Austin from 2012 until just last year in 2024. Scott practices both business and commercial litigation throughout all California state and federal courts, with a primary emphasis in construction and real estate litigation, public contracts, and complex contract disputes. In addition to his litigation practice, Scott has significant experience drafting and negotiating all types of public and private construction contracts, including design build and energy service performance contracts, and related construction documentation across various construction project delivery systems. Scott received his JD with distinction from the University of Pacific McGeorge School of Law in 1997. Prior to receiving his law degree, Scott facilitated municipal finance transactions and drafted related legislation for the California Housing Finance Agency. He graduated from Rhodes College in Memphis, Tennessee, with a bachelor's degree in business administration and economics. And after Scott and Ken present, we will be joined by Aaron Silva, also of Murphy Austin. And Aaron is the co-managing partner of Murphy Austin, where he leads the labor and employment practice team. He has an extensive background defending employers before state and federal courts and several administrative boards, including the National Labor Relations Board, the California Division of Labor Standards Enforcement, the California Workers' Compensation Appeals Board, the California Unemployment Insurance Appeals Board, and Cal OSHA Appeals Board. Aaron was awarded his JD from the University of California Davis School of Law. Prior to joining Murphy Austin in 2007, he worked for both Cal OSHA Appeals Boards and the California Public Employment Relations Board, so he has a great perspective of both sides of litigation in those matters. Lastly, Aaron is also the host of the HR Legal Cast, a monthly HR-focused employment law podcast that provides timely information about changes in the laws that will impact California employers the most. If you do not currently subscribe, I encourage you to do so. They are short, impactful, and oftentimes entertaining. Having said all of that, gentlemen, I will now turn it over to you and look forward to today's presentation.
All right, Edward, thank you very much. And Jillian, thank you. Again, we're partners here at Murphy Austin. I'm Ken Schumacher. One tidbit I do want to add to Scott's bio is he went to college with Supreme Court Justice Amy Coney Barrett. Yes, I did. And I don't know if you knew her or not in college, but she might have studied with her.
Probably a little bit.
But anyway, again, we really appreciate the opportunity to speak with everybody today on the construction and employment labor law updates. We've been doing this probably at least a decade. And so hopefully many of you have come and seen us speak before. But our firm, Murphy Austin, is located here in downtown Sacramento. We have, I think, 35 lawyers currently, a wide range of practice groups. Obviously, construction, labor, and employment is represented today. We also do real estate, healthcare, tax, corporate, our main practice areas.
And as Ken indicated, we've been presenting this update with Bender for probably a decade now. Ken and I do quite a few seminars, not only legal updates, but many other topics. I think some of the attendees maybe have been to a few of our seminars. We very much like on the construction topics to be as interactive as possible. I know through this venue with a video presentation, not quite as conducive, but please, we do welcome thoughts, questions as we're presenting, please make sure you do type that in. And when we come to a brief pause, Jillian will raise those, because we do find many of the attendees have told us they get the most out of these sessions when they have questions or things that are triggered based on the topics that we're presenting. And from our perspective, it's always great to hear from those in the proverbial trenches, if you will, that are actually dealing with some of these issues on their projects.
Next. There's our introduction again. Next, please. All right, and again, what we're going to discuss, Scott and I will start out for the first half of the webinar today. We'll be talking about construction law updates in 2025. And also we're going to revisit a couple of the more important appellate cases that came down in 2024. I think there's 3 cases we're going to be chatting about. And then Aaron will bring us home with employment and labor laws for 2025.
And we also, time permitting, will have time for some questions and answers at the end. Okay. Next slide, please. All right, so before we start, and again, those of you may have seen some of our seminars, we always start out with what's special about today. You know, sometimes it's a particularly important day when we are presenting, other times not so much, but a couple important things are happening today outside of this update seminar. Next slide. Today is actually, it's National Do Nothing Day. And it is what it sounds like. It's a day to celebrate doing absolutely nothing. We have no clue what the background of that is, but it popped up on the calendar as Do Nothing Day. So we're breaking with the tradition today, unfortunately.
Yeah, and I'm pretty sure it's not a state or federal holiday, but I wish it was. But nonetheless,
it may be in the future.
Next, please. And then the next day is it's International Hot and Spicy Food Day, which I guess if you did nothing, you could also go and eat nice hot and spicy food. So hopefully some of you are going to partake in this. You can celebrate this special day. All right, next please. All right, we're going to start now with the new construction laws. All right, so the first 3 laws that we're going to talk about relate to license laws, and there's always additions and changes and modifications to license laws. They're always trying to fine-tune those procedures, and those are administered typically by the Contractor State License Board, the CSLB. And so the first one that we're going to visit here is actually a law that was in place in the middle of 2024 as of July 1st, and that was AB 336, which amended part of the Business Professions Code. And you will find the license laws in the 7000 series of Business Professions Code. That's typically where they are. Easy to look up online. We have books with them here, but we also do look online. So if you ever want to know what the license laws are, that's the area in the code section you're going to focus on. So what the law was that contractors had to file a certificate of workers' comp insurance. They file workers' comp insurance, must certify on their license renewals what the workers' comp codes are, which the insurance is effective. And typically the classification codes are the nature of the work performed. So it's just another step that when you renew your license, you don't have to do it if you have an existing license, you're not renewing it, but if you have to renew it, you need to provide the workers' comp codes. Next slide, please. All right, a lot of words on this slide, but this again is an amendment to various sections of the Business and Professions Code. And really the major takeaway from this change, which was AB 2622, was you did need a license if you did work that was at a minimum of $500. That was always the threshold. I think some people would have handy people come over and do a couple $100 worth of work, didn't necessarily need a license. The license law has now changed to where it increased the maximum aggregate contract price to $1,000 from $500, and also indicates that you do not need a license if the work does not require a building permit. So in other words, so people come over, the contract is $900, doesn't require a building permit, that contractor does not need to be licensed. So that is the change really ultimately for what this slide requires. I think for most of you, not going to apply. Right?
Yeah, and it's no change, Ken, to the owner builder exception, right?
Right.
So that's still in place, and you may see this a little bit for those who may be on some of the apps like Nextdoor and some of the neighborhood apps. I've actually already seen more individuals soliciting as handymen to do more work, handy persons to do more work. So just be aware that there is that increase in what that minimum amount is to do work without a license.
Yeah, and the last bullet point in the slide talks about what the potential penalties are, and it indicates that it could be a misdemeanor. And we do want to emphasize, a lot of the violations of various license laws can lead to a misdemeanor, not a felony, but a misdemeanor. And so, again, I don't think hopefully anybody on this webinar is going to be impacted by this or it's going to violate license laws, but just be careful that if you do violate license laws, it's not only potential civil liability, you could have your license suspended or impacted, there could also be misdemeanor liability for you. All right, next slide, please. Okay, and again, further changes to license laws was SB 1455. So this eliminated first the requirement of an employment duty statement be included when applying for a contractor's license. So what this really relates to is to qualify for a license, you need to be an RME, which is responsible managing employee, officer, manager. And so that's either an RME, an RMO, could be an RMM, which is the manager aspect for LLCs. And so typically in the past, you have to provide certain statements and verifications of employment. You do not need to do that. But really the biggest change in SB 1455 was it gave further definition to what is direct supervision and control. And what this relates to is, in order to be a valid qualifier, you need to have direct supervision and control of the work as an officer. And this is subject, Scott and I have litigated this issue a few times, and it does expose people to liability if they're RME or RMO, because again, not exercise direct supervision and control. And what this statute now has expanded or at least clarified the definitions to mean there's 4 different areas in which you can exercise now direct supervision and control. The first is you supervise construction operations. Makes sense. Somebody's in the field actually supervising the work. Second is managing construction activities by making technical and administrative decisions. So this is a little broader than the prior definitions, and this is similar to case law that came down a few years ago on this. So you could have a qualifier who may be a high-level executive, and often they are. It could be a vice president, it could be a president. They're not necessarily in the field, but if they are managing activities by making technical and administrative decisions, they're a proper qualifier for a license, and they're exercising supervision and control. And that could be financial, that could be dealing with change orders, with contracts. They don't give a true definition further than that, but I think that it gives us some clarity in terms of the types of scopes that a lot of RMEs and RMOs can control. The third is checking jobs for proper workmanship. Okay, so again, you may not be out there supervising actual work, but the person may show up and be a quality control manager to make sure the work is done properly. And then finally, supervision on construction sites, which is actually similar to the first one, but they get a little bit broader. So again, this addition to the Business Professions Code gives us clarity, helps us a little bit because the area was gray. Now, again, I'm sure there's going to be litigation because that's what lawyers do as to what is technical and administrative decisions, but at least it gives us a little more guidance.
And each of the 4 categories that you identified, there's an or after each.
Correct.
It only needs to be shown that the qualifier satisfies one of those. I think, and as Ken alluded to, part of the vagueness here was because when you have especially very large contractors who may at any one time have hundreds, if not thousands, of projects going on, it's certainly impossible for any individual to exercise control or have direct participation in each and every project. And as previously drafted, the statute is somewhat vague as to what level of involvement would be required to satisfy the qualifier's obligations. And while there's still some vagueness in this, I think it's expanded enough so that the administrative function is likely going to satisfy that qualifier's obligations.
Yep, exactly. So it's helpful. It's helpful because, again, like I said, this is an issue we've litigated, never went to trial on it, but definitely has been raised in cases, at least for the argument that the qualifier was not proper, which could deem the contractor to be unlicensed if they don't have a proper qualifier. So again, it's an important distinction. As the slide indicates also that these statutes, the statutory changes permit federally recognized Indian tribes and participating tribes to obtain licenses and also exempts them from certain requirements. I'm not going to go into all of the details, but again, if you're doing work with tribes or tribes are going to be exercising controlling projects, you're going to want to look at changes in the Business Professions Code. It's also a requirement that public agencies verify that contractors hold proper license for work. So most public agencies we know identify what licenses they want contractors and subs to have, and now there's going to be a duty on them to verify. I'm not sure what the penalties would be, but again, it's really a check and balance is what they're requiring. And the laws also require the CSLB to establish a process by 2027 to verify contractors exempt from workers' comp insurance are in fact exempt. So this is the proverbial kick the can down the road, and I'm sure the CSLB will try to ask to extend that past 2027. But again, this is another requirement that they're going to have the CSLB try to enforce enforcement and to determine if there's exemptions from workers' comp or not. And then finally, the delaying the implementation of mandatory workers' comp for all contractors, regardless of whether they have employees. And so this was a prior law that was supposed to go into effect January 1st, 2026, but now they pushed it back to 2028. So like I said earlier, they kicked the can down the road. This is an example where the CSLB was supposed to implement a program to make sure that all contractors are workers' comp, regardless of employees, and now they're going to push it back to 2 more years.
Okay, next slide. Julian. Thank you. Okay, so Ken covered a couple of the legislative changes in California regarding some licensure statutes, and we're going to pivot for a couple of minutes and talk about some of the changes that were adopted by the legislature with respect to procurement in California. So first, we're going to touch on briefly is AB 1957, which amended several public contract codes. And there's been, I think as many of you in attendance today have had experience with, there's been a pivot the last decade, maybe a little longer than that even, in California, moving from the traditional public procurements, which is design, bid, build, where you have the procurement award is based on the lowest bidder, lowest responsible bidder, and transitioning to different procurement methods that allow the public entities to consider things in addition to price, various qualifications, experience, and that type of thing, more akin to the federal standard. And a number of years ago, California launched various different pilot programs applicable to counties, which is the subject matter of this statute, but also special districts and cities and all types of other public entities to allow them to perform projects given a procurement that's awarded on something other than a low bid. And several years ago, the legislature enacted Public Contract Code sections 20155 and 20155.1, which allowed a certain number of counties identified here, primarily Bay Area and Southern California, although there are the counties also included, to be essentially participate in a pilot program. So for public contracts that are anticipated to be awarded in excess of $1 million but less than 3, to use best value, which essentially allows the public entity to publish a series of criteria on which they're going to judge the submissions, bid submissions, if you will, from the contractors based not only on price, but on qualifications. And because of the success of that program, success in the eyes of the public entities primarily, but also I think of many contractors, the scope of that bill has been extended to now allow any county in the state to utilize the program. And it also removed what had been a sunset date of January 1st, 2025, to allow this program to continue into the future until such time as the statutes are later amended. So at this time, any county in the state can issue a procurement for a project and award it based on best value, where the anticipated range of that award is between 1 and 3 million. It doesn't require them to use the best value process, but it allows them to. Our expectation is we will see more and more counties using that type of procurement as we move forward. And as a corollary, while we're focused on this statute, over the last several years, many other statutes have been amended, the legislature, including statutes applicable to special districts and cities that are allowing a traditional design build and also now progressive design build to be used for a host of new projects. So we anticipate the next couple of years is going to be pretty exciting. We're going to see a lot of alternative delivery systems out, which I think the ultimate result is going to be additional competition, but also I think additional collaboration between public entities and between the contractors on projects, which the hope at least is that's going to make it a better project, a more efficient project, and cut down on disputes.
Yeah, and I would just add, this really is the trend. So Scott indicated every year there seems to be more and more bills that are allowing for best value. We're getting away from the traditional Tuesday at 2 p.m. hard bid, competitive bid projects, more flexibility, which really does follow more the federal model. The federal projects have definitely allowed for best value evaluations for procurements for years. So I think California is shifting, and I think public owners do like that. Most contractors like it too, a little more flexibility in this process.
Okay, next slide, please. Thank you. Okay, so the next legislation we'll talk about, AB 2192, which amended a number of sections within the Public Contract Code. And what this bill did essentially is make some modifications to an act called the Uniform Public Construction Cost Accounting Act. And again, this is another path for certain public entities to modify how they proceed with public procurements. Under the Public Contract Code, public entities, if they elect to be subject to this act, they're allowed to essentially change the thresholds for when they have to competitively bid work. Previously, if a public entity agreed that it will follow this act, and what the act requires is that the public entity provide various very comprehensive accounting reports that meet general accounting, accepted accounting principle standards, which many public entities don't necessarily have the ability because of their size or expanse to actually comply with, but quite a few public entities do. And if they agree to be subject to the act and make these various submissions to the state as far as how they account for dollars, they're allowed to essentially self-perform work with their own forces up to, was $60,000. This bill expands that to $75,000. And then it allows them for projects that would be up to $200,000 historically to be negotiated, done by purchase order or force account. This bill expands that threshold to $220,000. And then it also provides another expansion to the extent that there is a contract that's negotiated and it's in the zone slightly above that $200,000 that allow the public agency to award that through this process, through an informal process, up to, was $212,000 and now it's up to $235,000. So it doesn't change the requirements. It just simply allows a little more flexibility for public entities to do more smaller projects, maintenance projects, those type of things, without having to go out and competitively bid. And in exchange, they have a lot more information they got to provide to the state. Okay, next slide, please, Jillian. Okay, next is AB 2579, which amended provision of the Health and Safety Code. And many of you may remember a number of years ago, it's probably been a good 7, 8 years ago.
Pre-COVID.
Pre-COVID, there was that horrible accident in Berkeley, the collapse of the deck, where there were a number of students, I believe, that were on the deck. And that the fallout, unfortunately, from that event was tightening the standards on inspections, and there were various statutes that were enacted afterwards. One of them is the subject of this bill here, which is Health and Safety Code 17973, and that required that there be inspections conducted at various entities, various structures, and it's worded very broadly. The law requires, authorizes enforcement agencies and jurisdictions to enter with very minimal notice and to inspect any building or premises when they believe it's necessary to secure compliance and prevent any violation of building standards. And primarily, you see that looking at waterproofing elements of buildings and elevated exterior decks. What this bill did is essentially extended the time for the inspections because of lack of funding, as well as lack of personnel to complete them, and just the scope of what has been tasked to the jurisdictions. So what this has done is essentially extended the deadline from January 1st, 2025 for the first inspection for a year, and then also provides that no inspection is required if the property had been inspected within 3 years prior to January 1st. We have a typo there, but that should be 2026. Okay.
Next slide, please. All right, so AB 179 adds provisions regarding job order contracts. I don't know if any of you have worked on job order contracts before, but they're basically on-call construction contracts where they previously negotiated usually unit prices. And what this bill allows is DGS, Department of General Services, State of California, to use job order contracting for contracts with a maximum term of 24 months and a maximum contract amount of $10 million in the first term of contract. It allows for 4 1-year extensions, and then also an increase to $5 million for each extension. And the job order contracts cannot in themselves exceed $1 million, preventing wages, skilled training workforce, all required. So this gives flexibility to DGS, and for the most part, I've seen this on larger buildings where they just need projects done, some maintenance projects, upgrade projects. They're going to contract with the contractor, establish job order unit prices, and then roll out the job order work orders is typically how they're issued. So this just gives a little more flexibility to DGS, and I'm sure again it relates to most of their new building projects flexibility. And if you can get job order contracts, they're usually pretty good work for at least for the clients I know who have done. All right, next slide, please. All right, the High-Speed Rail Act, AB 2879. So high-speed rail has been lucrative for lawyers. What do you say, Scott?
I would say so. Maybe not so much for the state, but for the lawyers.
Yeah, and I'm not going to provide political commentary on the effectiveness of our high-speed rail in California or if the monies have been used appropriately. But I think
when you want to go to Bakersfield, you're going to be able to do it.
I can do it. I can't wait. And so with this, I think the legislature realized that the high-speed rail projects are not being administered necessarily in a consistent or proper or efficient manner. So what this act has now created, or is going to create, is a high-speed rail authority that have 11 members, who they will be, to develop and implement a high-speed rail system in the state with specified powers and duties. They're going to be able to enter into contracts, private and public entities, for all aspects of design, construction, operation. We have an executive director. Well, that's going to be a big job. And the bill, though, notwithstanding the ability to delegate power, it's going to require any change order with a value greater than $100 million to be approved by the authority. So it's project director is going to have a lot of power, but obviously we're talking high level change orders. The authority is going to get approved. So no idea when this authority is going to be set up, who's going to be on the authority, how effective it's going to be. But I think they've realized that they need to at least get their arms around and have a consistency and have a centralized authority to hopefully marshal these projects through. They are not efficient. All right, next slide, please. All right, the Buy Clean America Act, California America Act, Clean California Act. There's America Act, but the Clean California Act, and we've talked about this a few years ago when we did some seminar for BenderU, established to have minimum standards. State contracting manual provides those in terms of global warming potential for categories of eligible materials. Not sure if this has impacted your projects or not, but it defines eligible materials, and there's a list of them: carbon, steel, rebar, glass. And one of the definitions includes the mineral wool board insulation. So what this SB 1207 has now done is it's revised the definition for insulation not to be limited to mineral wool board insulation, but now includes insulation of all types. So it just broadened the category and the definition within the Buy Clean California.
No political commentary, but this is another example of legislation where you have some manufacturer organizations who were crying foul because their insulation products were being targeted. So they lobbied the government and they got that extended to all insulation materials now. And what the potential impact on cost and price for insulation materials remains to be seen. May have an adverse impact, but we'll have to see. We'll see. Okay, next slide, please. Next slide, please, Jillian. Thank you.
Okay, just want to make sure you saw it.
Yeah, we're there now. Thank you.
Perfect. Thank you. Okay, so believe it or not, that is a high-level summary of all of the significant, and we use that, in a relative term, direct construction-related legislation that was enacted within the last year. You hear from Aaron. There's a number of labor laws, obviously, that touch on contractors, touch on your businesses, but things are just purely construction. Not a lot this year.
Yeah.
It's been a good, probably 12 years plus since we had the real meaty, beefy mechanics lien modifications. Nothing like that this year. The last several years, it's been a lot of this. You take away from what we've discussed so far, a lot of targeted rifle shot legislation. Expect that to likely continue for the coming year based on what we've heard from some of the individuals that we know who were working in the legislature or lobbying in the legislature, but remains to be seen.
Yeah, and I think that the takeaway of all the legislation, Scott's right, nothing major, nothing earth-shattering. I think some of the clarifications or expansions are good. Obviously, the best value, trying to clarify some of the license law definitions, those are good things. And I think those are helpful, but nothing I think that's going to really change a lot of approaches in terms of contracting.
Exactly. Okay, so there was one non-direct construction law that we did want to raise and call everyone's attention to, because it is going to impact contracts and subcontracts and prime contracts for many of you moving forward. So I wanted to spend a couple minutes talking about one of the bills passed, SB 940, which made modifications and amendments to the California Arbitration Act. And within the Civil Code, there are various provisions that govern the handling of contractual arbitrations. And many of you in your contracts will likely incorporate arbitration provisions. And this, it touches on not only statutory arbitrations, but also arbitrations that may be administered through JAMS or through AAA, which may pull in the rules of the statutory requirements. And I'm not going to go into all of the changes in the California Arbitration Act, but wanted to touch on a couple that are going to potentially impact construction industry. Much of this act deals with changes to arbitration procedures in consumer cases. So to the extent you go to the store and you buy a phone or you buy another item, the very fine print that none of us read, but that's embedded in the purchase, are various consumer protections, and included in that many times are arbitration rights. So this act makes a lot of modifications to who can serve as the arbitrator, what types of disclosures, the neutrality of the arbitrator, the various things probably aren't going to impact, at least in your day-to-day businesses, on how you operate. But there are a couple aspects that very well may. Yeah, included in this act is now confirmation that an arbitrator can allow third-party discovery. And by that, I mean, when you have an arbitration that's pending, there's going to be various requests that may be made. Requests by one party or another party in the arbitration for documents or information, to take depositions, and for subpoenas or documents that essentially will order a party to either appear or to produce documents. And until this amendment, there was a lot of disagreement about the rights and the actual ability of a private arbitrator to enforce a subpoena that would make a third party do something, to produce documents or to produce an individual for deposition. The changes in the law now give the arbitrator essentially a very broad scope to enforce those rights. So if you are in an arbitration, and for instance, if you are a subcontractor and you have a dispute where you are in an arbitration with a general contractor, and there is a third party, maybe a designer or another subcontractor, the arbitrator can now force that third party to produce documents and or to appear in a deposition or in proceeding. And while that may seem like a minor change, it's an important one, because as we know, many times while you may just be involved in a two-party dispute, in that example I gave just between the subcontractor and a general, there may be other parties who have important information to provide in that dispute, and it's been difficult sometimes to get that information into the arbitration. So this change in the law modifies that. But there's also one other very, very significant change. The Arbitration Act previously did allow depositions to be taken and discovery to be obtained. However, the Act required that, except in disputes that involve personal injury or damage to person, that the arbitration agreement itself, in other words, your subcontractor, the prime contract that required arbitration, actually had to incorporate those discovery requirements. Meaning that if you had a contract that simply said, if we have a dispute and we arbitrate, and there was no mention of the discovery requirements, you may not be able to obtain any discovery. And that's maybe good, maybe bad, depending on the size of the dispute and what the nature of the dispute is. But the fundamental change in the Arbitration Act now essentially flips that, so that the statutory allowance for depositions and for discovery is now automatically incorporated to the extent the contract requires statutory arbitration. However, you can by contract exclude that. But so now you have to specifically exclude discovery from your contracts. So big picture, what does that really mean moving forward in drafting? Depends, I think, on the type of disputes that you have and the size of the disputes. I think many larger entities are going to are going to not insert any prohibition on discovery, because what this law essentially does is it puts arbitration almost on an equal footing with litigation. Historically, many entities have preferred arbitration because you get through the process a little quicker, many times, a little less expensive. But what this bill is going to do, essentially, is going to make many instances arbitration essentially the same as going to courts. You're going to have the same discovery. It's going to be many of the same costs. So we raise that because every entity and their appetite for risk and the types of disputes are somewhat different. But you will want to look at your contracts and identify, do we want discovery? Do we want to modify the allowance for discovery? Do we want to limit? So I think each of you may want to take a look at your contracts and figure what kind of modifications might I need based on the type of disputes that we have from the standpoint of expediency to get your disputes resolved, but also costs.
Yeah, and I think one corollary to that is, we haven't done this yet, but perhaps you could put a threshold, a monetary threshold in your contract and say if the total claims are less than X dollars, that we're not going to allow discovery. So like Scott indicated, there could be a small dispute that you want to fast track through arbitration. So perhaps the provision can kind of bifurcate those matters and say, for those smaller matters, we're not going to allow discovery. But it has been frustrating in the past. You've been in large cases, lots of parties, lots of dollars, lots of complex issues. And because of the way the arbitration provisions were drafted, didn't necessarily have the right to do discovery, including taking depositions, which you really would like to have prior to an arbitration hearing of that magnitude. So I think this is a good addition because I think you should have discovery rights, but I think it's not going to be one size fits all because there are some people that just don't want to do discovery, just want to get to a hearing. But some, I think, more sophisticated folks are going to realize, I think we need to have discovery rights. So I think this probably is a good trend. But Scott's right. You have to look at the contract provisions and really figure out how you want to deal with it. All right, let's go. Next slide, please, Julie. All right, so what we're going to talk about next are 3 cases that came down, and we said 2024. I think these are actually, some of these were late 23 into 24, and most of them finished up early 24. I don't think we found any cases that really from the middle to the end of 24 were relevant. And I will say this, taking a matter all the way through trial and then getting it to an appellate court and having a decision is very expensive. And so that's why we see cases, but we don't see a ton of cases because I think most of you, and I would agree with you, don't want to spend the money and on lawyers to go all the way through the appellate. So that's why we don't see often a ton of appellate cases on construction matters. So the first case we're going to talk about is Davis v. Fresno Unified. I think this is the 3rd or 4th case and this relates to leaseback. So this was years ago a dispute on the Fresno Unified projects. There's been other decisions regarding these projects and these parties. And what came out of the leaseback case, the Davis cases, there were substantial revisions to the leaseback laws, I think about 8 years ago, which cleaned up a lot of the issues that arose. But they keep litigating. I think the lawyer representing the taxpayers here he's really got his eyes on the prize and his bullseye is Fresno Unified. So what this appellate case dealt with was whether you could validate a contract, and there's going to be public works contracts that can be validated that they're legal, and you can ask a court to make a validation. You can also challenge a contract on what we call a reverse validation procedure and say it's an illegal contract. In this particular instance, the question was whether the contract could be validated or not when the financing for the project were bonds. So it wasn't money that the district had in hand. It was somehow third-party financing, debt financing mechanism. And what the court ultimately said was, well, that doesn't allow for a validation procedure. So we're just going to deal with the legality through a taxpayer lawsuit, and we're not going to make a determination. And that's what the appellate court ultimately decided. So it's a pretty discrete issue. It's a focused issue. Hopefully none of you are involved. We've been involved in one litigation on leaseback, which unfortunately went away. But nonetheless, the Davis cases keep on coming, and I'm sure we'll see another one in a year or two because it's keep litigating. All right, next slide, please. All right, next case is Suffolk Construction versus LA Unified School District. LA Unified definitely is a gateway to many appellate cases, interesting district to work with. And in this particular case, it dealt with Public Contract Code Section 1104, which hopefully most of you know, is it codifies the implied warranty of fitness of plans and specifications on public works projects. So in other words, when a public entity on the design bid build project puts out a design, the code section basically says the design is constructible, not perfect, but constructible. And it's often the basis for many claims by contractors that the design is not full, complete, and constructible. In this particular case, the district put out a performance spec regarding concrete, and the contractor tried to argue that the performance spec violated 1104, and what the appellate court ultimately determined was that's no, not true. You as the contractor for whatever means and methods you need to meet the performance spec, and that does not create liability for the public entity under the Public Contract Code 1104. And so I think it clarified the requirements. I'm not sure it's particularly helpful to contractors.
Well, I think it clarified, and it also muddied the water somewhat.
Yeah.
Even in this instance, I think the facts in this case where the performance spec really was based on aspects of the concrete mix, as I recall. But I think it does introduce some vagueness in about how far can a public entity go as far as what it wants to say is a performance specification, or really maybe the designer for a public entity is really what this is touching on, where they don't want the liability associated with conduit routing. They don't want liability associated with pipe routing. They don't want liability associated with routings and congested areas. And by turning more and more contracts into performance specifications and putting more loosely stated design obligations on contractors, even when it's not a design build, I think we'll probably see some more of these cases depending on how designers want to take it.
Yeah, especially on issues like deferred submittals and other aspects where you have to kind of fill in the blanks to get to where you need to go on a performance spec. So I think Scott's right. We may see more caveats, less detail, less specificity from the design side, and pushing more of that onto the contractors, which may not be the worst thing in the world, because it could be a means and methods. You could save money. You could have some control over the process. But again, this is an important case. And like Scott said, it could muddy the waters.
Next slide, please, Jillian. Okay, the last case that we will talk about before turning things over to Aaron for the employment labor update, K&S staffing. And facts of K&S are not particularly egregious or out of the norm. This case arose on a Caltrans project. Essentially, Caltrans contracted with general contracted with a subcontractor for a series of Caltrans projects. Things went swimmingly for years until they didn't, when the sub fell on some difficult times and initially lost its ability to obtain workers' comp insurance or adequate workers' comp insurance. So it decided to obtain labor through its staffing solutions, essentially an entity that provided labor. And eventually the sub fell on harder times and stopped paying K&S. And as part of their relationship, K&S paid the laborers based on a fee it received from the sub, but the sub was fully responsible for providing oversight and supervision of the work. When K&S wasn't paid, it filed a claim and made a payment bond claim and started litigation against Western Surety, which is the payment bond surety. And went through the trial court and then up to the Court of Appeal. What the Court of Appeal held is that a staffing company, here K&S, does not have the right to assert a claim against a payment bond because while it may be providing laborers, it doesn't satisfy the definition of a laborer under the statute because it's not an employee. The labor provided is not an employee. It's simply a service provided through the staffing company. So it's a subtle distinction, but one that, at least for K&S, had pretty significant ramifications because it wasn't able to get payment for the laborers that it provided to the site because the sub went bankrupt. Case is also important based on clarification that a payment bond that was issued here allowed for the recovery of attorney's fees to based on the prevailing party. There was some discrepancy between whether payment bonds issued on a state public work project, such as for Caltrans, would allow recovery of attorney's fees, because the statute allowing for that was located in a series of statutes that dealt with issuance and requirements for payment bonds on local public work projects, which local public work projects are projects other than state projects. But the court made kind of an important stretch of the law here and said, well, even though on its face the prevailing party provision may not apply, we believe the legislature intended it to apply to all payment bonds. So based on this case, any claim under any payment bond on a public project is also going to allow the prevailing party the right to recover attorney's fees. And in many of these cases, once you get far enough into litigation, hopefully many of you have not had to experience this, but attorney's fees sometimes drive the bus as far as resolution, and also taking a case through to trial when the attorney's fees get to a certain point. So with that, unless there are questions for Ken and I, we will turn this over to Mr. Silva.
All right, next slide. Okay, don't get too intimidated by the graphics. Oh no, the slide before that. There we go, yeah. All right, so I saw the reservation list for this presentation. A lot of you have done this with me and us for several years now. So you know how my part goes, right? I start off in December going with a new seminar about new laws for 2025, and then that's about a 2 to 3 hour presentation that I'll do. And then I will take that out on the road, and then I'll modify it depending on what my audience is. So I've done this presentation several times. This is a presentation that has a contractor bent to it. So that's how I am approaching this one. This doesn't mean that these are the only new laws or the new regulations that are going to affect for 2025. It's just, this is what I thought was the most applicable for your particular industry. So as far as questions, as we typically do, just ask them as we go along. We can do an AMA. So you can ask me anything you want, because we oftentimes go off on tangents with employment law, which is absolutely fine. So put me on the spot. I enjoy that. If you do ask questions, I just ask that they're general and they're not specific. So I don't necessarily want to hear about your employee that's doing X, Y, and Z, because that would be a privileged conversation. So I always reserve the right to just say that we can take that offline. If you got my contact information, so you can always email me or call me. I prefer you call me, and then we can do it that way. So just like with Ken and Scott talking about what the state of the legislature is with their industry and what they're doing, that of course never applies for employers. They are always on your case doing something, right? So there are bad years. Think ban the box, CFRA going to 5 employees. Last year, workplace violence prevention plans, which remember get those into place. They were due July 1st. And then of course, prevailing wage never gets easier to understand, right? So I wouldn't necessarily say that that was this year as far as a whole or a horrible year. It was more of a moderate to an okay year, actually. But even if it wasn't, right, we get through this stuff together because we have each other. At the end of the day, that's really all that we need, right? So it's kind of a moderate to an okay year. I'm going to say that because of the PAGA reform, which was huge, and we'll get into that. But why don't we go to the next slide and dive into this stuff? There's a graphic. I can do graphics too. Wage and hour, this is the bread and butter of any employer side, which is what we are, an employer side labor and employment practice. So I would say at this point, I have like 20 pieces of litigation that we're actively doing. I think 17 of them are wage and hour stuff, mostly class action and PAGA type stuff for how people are getting paid, if they're getting breaks, pay stubs, all the popular things. So wage and hour is always the most popular. And we're going to start our first slide as we do every presentation every single year. So here we go. Minimum wage. Minimum wage. Yes, it went up because it goes up every single year. It could have gone up a lot more based on what happened in November, because we did have a minimum wage initiative on the ballot, but that didn't pass. So we have gone to now $16.50 an hour. So you might recall that for years and years, there was actually 2 different roads that were being taken by small employers who had less than 25 employees, and bigger employers, the employers that had more than 25 employees. We have now merged. We don't have this distinction, so we're all on the same road. We're all in it together, and it's now $16.50 an hour. Now, there are certain exclusions in the fast food industry and in the healthcare industry as far as their minimum wages, which is higher. According to my buddies in the legislature, this is something that you can expect to see more and more, is that different industries are going to start getting their own minimum wages. Now, I don't know when that happens, but I would think that construction's probably going to be on that, right? I mean, in my opinion, the legislature has slowly been trying to incorporate prevailing wage concepts into private works for several years, right? So we'll see what happens, but for now, it's $16.50. Now, you're probably screaming, why is this the first slide that we're doing? Why do you do it every single year? Well, maybe you're not screaming about it, but you're thinking about it. And I tell you the same answer every single year, right? It's not necessarily that maybe you don't have minimum wage employees, that's fine. But the minimum wage affects more than just them. It affects, right there, your exempt employees as well. Now, why is that? Well, there's three very popular exemptions in California: the administrative, executive, and professional. But administrative and executive are the two most popular. Both of those exemptions, so exemption means an employee that doesn't get overtime, they don't get breaks, right, as compared to a non-exempt that gets all of those things. But one of the requirements, and there are several requirements for exempt status in California, is that exempt employees have to get a salary that is on a monthly basis more than 2 times the state's minimum wage. So when there is an increase in the minimum wage, which happens every year, your exempt salary threshold also increases. Remember, it's based on a monthly period. So if we take our new minimum wage, $16.50, that's going to raise the annual amount that you have to pay to your exempt employees to $5,720 a month. Or if you're looking on an annual basis, $68,640. Now, that's the most obvious example, but the minimum wage also affects other things. For you unionized employers that are on this thing, there are certain exemptions that apply to unionized employers if certain requirements are met. And one of the most common requirements is that the employees, all of your employees covered by the CBA, gets at least 130% of the minimum wage. So once again, minimum wage generally goes up. A lot of other things that are not directly related to minimum wage employees also goes up as well. So check your salary numbers to make sure that you are in. Next slide. All right, freelance worker protection. So this goes to AB5. So you know that I am not a fan of AB5. It took a very simple concept, or I should say a simpler concept, which is independent contractor status, and it made it incredibly complex. So that started happening in 2018 with the California Supreme Court decision in Diamond, which said, okay, for independent contractors, instead of having, it was anywhere from like a 13 to an 18 multi-point test, and it was weighed, so one factor didn't, necessarily be the end of the world, but basically it took a lot of discretion out of the courts and administrative agencies to decide what independent contractor status is, and it made it much more rigid. So from that case, they announced something called the ABC. And then the next year, we got in the legislature AB5, which codified it and made that Supreme Court decision actually in our labor code as to what it is and is not an independent contractor. Here's the problem. That law in particular is incredibly complex because it's not just about ABC test applying to all employees. There's a bunch of lobbyists for different industries, obviously trying to get carve-outs. And so we took this very simple law, or a very simple concept, and we have all these carve-outs, which makes independent contractor status incredibly complex to do the analysis on. And this is yet another thing. This is another carve-out to try to deal with AB5 in the form that you're seeing there. So it's dealing with freelance workers. So let's start with a real basic concept. What's a freelance worker? I didn't know before I saw this law. So we have a definition in the statute. It means that it's no more than one person. So this is aiming for solo practitioners or proprietors. It's no more than one person that's retained as a bona fide independent contractor to provide professional services in exchange for more than $250. So in order to do that, in order to fall within that realm, you have to have a written contract with that individual. That contract has to have a few things. It has have an itemized list of the services and their value and how the compensation is going to be calculated. It needs to specify what the payment due dates are going to be, or the mechanisms for determining when that due date is. And then finally, the due dates the freelance worker has to report completed services in order to get time payment. Now, once that work begins, the hiring entity can't require the worker to accept less than what they have bargained for in that contract, or provide more services than what they have already agreed to do in exchange for the same amount of money, right? You'd have to do some sort of amendment to the agreement. So if you look at the first bullet point, it talks about freelance workers providing professional services. So what are professional services? It's a range of creative and intellectual services. So I'll give you a few examples there. Marketing, HR, travel agents. See, this is one of those lobbying groups that got involved in this whole process. So you'll see these industries that you wouldn't necessarily think would pop in, but there you go. Travel agents, and then creative fields, graphic design, fine arts, writing, licensed professionals, and other specialized programs. Next slide. All right. So I think my least favorite law in California is prevailing wage because it's so incredibly complex. My second least favorite may be PAGA. So let's go to the next slide. So a little bit of history. So PAGA stands for the Private Attorney General Act of 2004. So we have in California a very, very thick book of laws that applies to employers, and it's called the labor code. So there's all these things in the labor code, and some of them, this is what's dealing with, like overtime, rest breaks, meal breaks, pay stubs, split shifts, all of the employment law concepts, right? But there's a lot of things that are in the labor code where it says you can't do this, and if you do this, you have to pay a penalty to the state of X amount of dollars. Or it just says you can't do this, but it doesn't tell you what the penalty is, right? So you're prohibited from doing it, but it doesn't say what the consequence for that is. But we go back to 2004. So Gray Davis has just been recalled, and he is on his way out of the office, or out of the governor's office. The state is coming to the legislature and saying, hey, there's all this stuff in the labor code that says there's penalties and that we can recover them. Or there's other stuff in there that it says you can't do, but there's no penalties. But we just don't have the resources to do this. So help us out, legislature. And what we got was the Private Attorney General. And so what that allows aggrieved employees to do, so these are people that are affected by the violations in the labor code, it allows them to be deputized as attorney generals. They become private attorney generals. It's the acronym, right? So they are deputized as attorney generals to come and sue their employers for these violations, but they're doing so not in their individual capacity. So it's Aaron Silva or whoever that might be, but they're doing it on behalf of the state of California. So the default, because we have reforms, so these are the old rules, but the default penalty, if there wasn't one in there, was $100 per employee per pay period for an initial labor code violation, and then $200 per employee per pay period for each subsequent violation. So it used to be that pay periods, and we'll talk about this, especially for you folks in the construction industry, it's by the week, right? So you're not doing it every other week or 2 times a month, right? You're doing it every week. So PAGA hits you really hard if you ever got one of these lawsuits, especially if you had a lot of employees, because you can see how those penalties add up really fast. Now, here was what made this law so enticing to the plaintiff's bar. So those are my opponents. And it's because if you, as the employee, recovered a single cent from your employer for one of these labor code violations, you not only had to pay your attorney, so me, you'd have to pay the plaintiff's attorney as well, right? So that's what made this so enticing. And so you saw PAGA cases when this law first came out. I think there was like 30 lawsuits the first year, but we were in the thousands last year. I mean, this thing really expanded. So at the end of the day, it used to be, this rule has changed now, we'll talk about it. It used to be 75% of recovered penalties went to the state, Force Development Agency in particular, and then the remaining 25% went to the aggrieved employees, right? But this was all about attorney's fees. It's always about attorney's fees, which made this so enticing. So this law was not very popular because it's effectively a class action. But if you have a class action, there's certain requirements you have to satisfy. You didn't have to do that with this. So it was like a class action, but you didn't have to do all of the requirements. Like you have to have a certain amount of people in a class action, or there has to be common facts or common legal theories. You didn't have to have that. So that's why this thing exploded. So that upset a lot of employers who don't have a lot of political power in this state, but Cal Chamber and some of their allies started floating an initiative for the November ballot. It started polling really well. So the state, and specifically the governor and some of the leaders in the legislature, started to negotiate about a reform package for the PAGA, because the initiative was effectively getting back to law. And so what you ended up getting in June was a huge reform to PAGA, which, although there are some things that are good for employees or good for the state, in my opinion, most of it, not all of it, but most of it is good for employers. So let's go to the next slide and talk about it. So I did a whole seminar on this for Bender over the summer. So I think that was a 2-hour one. So I'm trying to condense and keep this really short. So it's a really complex reform. Usually I can go through these laws in about 15 minutes and actually summarize them into a slide and be able to present them to you today. This particular piece of legislation, I think it took me about 6 hours to do, to actually go line by line through this thing and actually do a presentation. It's really complex, but here's the highlights. So let's talk about some of the problems that existed under the old version of PAGA. So one of the biggest problems that we had is that it's the aggrieved employee that is actually bringing the lawsuit on behalf of the state. But if that one aggrieved employee experienced a single PAGA or labor code violation, they could sue for all PAGA violations on behalf of others, regardless of whether or not they were personally affected by it or not. So let me give you an example. We've got a plaintiff who claims that the only labor code violation they ever personally suffered was on a single occasion they missed a meal break. One occasion. Under the old version of PAGA, under this Huff case here, that person had the ability to sue for all other labor code violations on behalf of all their other coworkers. So they could say, hey, I didn't have a problem with rest breaks, but my buddy did, or I didn't get over it, or I got overtime, but my buddy didn't. But that person, that plaintiff, could still sue to recover those things, which was horrendous. So you would get these people that were at these employers for like a month or two. They'd bring a PAGA case. They maybe would have one issue, but they would sue for basically everything in the world. So when you went to settlement or you were getting closer to trial, the settlement value of that case was tremendous for employers. But there's a fix. So now under our PAGA reform bill, aggrieved employees have to have personally suffered each of the violations alleged in the lawsuit. So now hopefully that limits it down. And I think I've taken on about 4 PAGA lawsuits since June when this thing went into effect. I've seen that narrowed, so it hasn't been as big of a deal. Next slide. Defining subsequent violations. So remember, it was a $100 initial penalty amount per pay period per employee. And then it was subsequent $200 for each penalty thereafter or violation thereafter. So let's do a hypothetical 1 week. And say you have an employee that didn't get their meal break on Monday, Tuesday, Wednesday, Thursday, Friday. Now, me, being an employer side attorney, always argued that that was all an initial violation. So it should just, let's assume we got one employee. So it's $500 in penalties. It's $100 for Monday, $100 Tuesday, $100 Wednesday, $100 Thursday, $100 Friday. Courts had primarily gone that way, but it was somewhat split, right? But that was the argument that we were making, usually successfully, that we didn't have notice that we were doing anything wrong, right? It's not like a court had told us in the past or an administrative agency like the labor commissioner had told us that we were doing something wrong. So we weren't on notice. So it's all an initial violation. The plaintiff's bar would argue the opposite. They would argue it's $100 for Monday. That's the initial violation. But it's $200 for Tuesday, Wednesday, Thursday, Friday. And we would always have a fight about this. And most of these cases end up in mediation, settlement discussions, and they would do their side, I would do my side. But anyways, we do have a fix to that. So we now know that the $200 subsequent penalty applies when an agency or a court within the preceding 5 years has found that the employer's policy or practice giving rise to that violation was unlawful, right? So it's like 5 years, you got to look back. And the $200 also applies when the court finds that the employer's conduct giving rise to that violation is malicious, fraudulent, or oppressive. That's punitive damage language right there. It's a high threshold to me. So I don't think that's going to come into play with potentially only the worst employers. It's going to be more the first factor, but it is a fix, so that helps out. Next slide. All right, we get to cap some penalties too. Remember, $100, $200, right? But we now have some caps. So one of those most popular PAGA claims is for pay stub violation. So pay stubs are that piece of paper that you give to employees that have it's 9 pieces of base material. So it's going to be names, employee ID numbers, gross wages, hours worked, hourly rate, stuff like that, right? And there's other laws that will come in occasionally and say that this needs to be on pay stub as well. But we do have caps on that now. So we have a $25 cap, 2 of them actually. The first cap applies that when a pay stub is incorrect for reasons unrelated to employer name or address, okay? So say it's a situation where you have how many hours that were worked and what the gross wages were, but you don't necessarily have what the hourly rate of pay is, right? So it's going to involve that sort of situation. If that's the case, this $25 cap is going to apply if the employee could promptly and easily determine from the wage statement alone what the accurate information is. So if you know how many hours you work and you know what your gross wages were, you could do a little bit of math to figure out what your hourly rate of pay is, right? So that's probably when this would apply. The other $25 cap applies when the pay stub violation is related to employer name or address. You'd be surprised as to how many cases there are where the employer's name or address is either not on a pay stub or it's somehow incorrect, which does happen. So in that case, if we have a pay stub violation related to those issues, another $25 cap applies if the employee would not be confused or misled about the correct identity of their employer. And if you get bigger organizations with subsidiaries or sister corporations, other corporations, that can come into play. But that's where this cap comes in. And then we have a $50 cap for pay stub stuff. And that $50 cap applies when the violation was caused by an isolated, non-recurring event that lasted less than 30 days or 4 consecutive pay periods, whatever is less. All right, next slide. Okay, and we do have more things that are capped, and it's all about reasonable steps. So we do have penalties that are capped at different amounts depending on if an employer takes all reasonable steps to comply with the law and when those steps are taken. So we have 2 big dates. So if you have a PAGA lawsuit, the first thing that the employee is going to do, or their lawyer is going to do, is that they are going to file a notice, and you will get a copy of it with the state of California. And state, we intend to sue this employer for all of these labor code violations under PAGA. But state, you get first dibs at it. If you want to do it, you go for it. But if we don't hear back from you for a certain amount of time, then we have the ability to come in and file our own lawsuit. That's called exhausting your administrative remedies. Right, so you're going to get a notice if you're an employer that this is going to happen. By the way, when you get those notices, that's when you talk to someone that knows something about PAGA to get some advice as to what to do going forward. But we have 2 different caps depending on when all reasonable steps are taken. So there's a 15% cap on all those penalties if all reasonable steps are taken to comply with the alleged violation before the PAGA notice. So that's that letter that's going into the state, or you get a request for personnel records. So a lot of employers, especially in your industry, will get those letters. There's usually 2 firms in particular that are sending them out saying, we want our client's personnel file, we want their pay records, and we want their time records, right? So if you get one of those letters, or you get the notice to the state, that's when this deadline or timeline is starting. The other cap is at 30%, and that's if all reasonable steps are taken to comply with the alleged violations within 60 days after the PAGA notice is received. So the pro tip there is you don't want to ignore those PAGA notices because there are dates that are, or there are deadlines that are coming into play when you get that notice. Next slide. All right, so you're probably asking what all reasonable steps are. Here's a slide that talks to you about what all reasonable steps are. So it's evaluated by the totality of the circumstances, which is a very vague concept. And it basically means it gives the court a lot of discretion to determine whether or not you, based on your size, based on your resources, what do you do, what are the nature of the allegations, did you take all reasonable steps? So that gives the court a lot of discretion, which is nice, but it can cause issues. Now, this doesn't apply when, once again, the violation is malicious, fraudulent, or oppressive. Again, that's punitive damage language, so that means you did something really, really bad, or you had a really, really bad intention of doing it. So the existence of a violation, even if it's found at the end of the day, doesn't affect whether or not all reasonable steps were taken. Now let's get down to what all reasonable steps mean. So if it's that first deadline, the 15% cap, here are the reasonable steps that an employer would have taken before they got that notice or before they got the request for personnel records. 1, they would have performed periodic audits and take appropriate actions if they found problems. So you're looking at your payroll, you're looking at your pay stubs, when I've been in this situation, because I've had a few PAGA lawsuits since then, I'm having the employer basically take, audit 5 employees, 6 employees for the last year, take their pay stub. You can very easily see whether or not the pay stub complies with the base requirements, but then compare it for a couple months against their time cards or whatever your time records are to see if everything is fine. So that's what an audit is. And then obviously, if you find a problem, you're going to want to utilize lawful written policies. So this is where it becomes very important that you have those policies in place to begin with, but they also have to be lawful. And if you don't have them, you need to get them in place. So even if you don't use an attorney, that's perfectly fine. HR consultants, I know plenty of them that are great HR consultants who do that. So there's lots of different resources that you can use. I know that there are some online avenues that you can take as well. Just make sure that they're California centric. Remember, California is a very unique state when it comes to employment law. Lots of other things, so you want to make sure that you're. 3, you want to train your supervisors on wage and hour complaints. So, for years and years, I was the chair of the personnel committee here at Murphy Austin. So when this law came out, we are an employer, I'm a partner, I have an interest that my firm doesn't get sued. So I did training for all of our partners, all of our associates, and other supervisors. And it was just a real basic, like 10 to 15-minute presentation that I did, just talking about, okay, what are meal breaks? What's the timing on it? When do rest breaks take effect? What are common signs that you look for to indicate that someone's, not complying with like clocking in or clocking out? How do you deal with those situations? So it was very basic stuff, but kept a record of it. So if we ever have issues, right, I have something that it actually makes it an affirmative defense. And then finally, take corrective action if you have issues with your supervisors. A lot of supervisors don't necessarily know what they're doing in wage and hour stuff. Employees might complain to them or say something about a wage and hour issue, and then the supervisor just doesn't do anything at the end of the day. And that's not good for you because if it's a supervisor, the supervisor is your company. So it's basically one and the same, right? So you want to be mindful of your supervisors and make sure that they understand what a potential wage and hour issue is and make sure that they get that up to the right person that can deal with that. Next slide. Then we're looking at the post-PAGA notice. So this is the 30% cap. It's basically, you can look at the bullet points there. It's basically exactly the same thing, right? So what's the pro tip here? Take your reasonable steps now. You can do that. This is something you can do now. It doesn't take a tremendous amount of time, but it's the beginning of the year. So this is the time that you should be looking at your handbooks and your policies, take a look at your pay stubs, but do this as well. Have this on the list because it can be incredibly helpful economically if you ever get yourself in a problem with this PAGA law. All right, next slide. Secure to not secure. So there are certain PAGA violations that can be cured if certain steps are taken at certain points in time. And that includes meal break violations, minimum wage violations, OT violations, failure to reimburse a business expensive pay stub violations. If you do certain things, you can cure them. Open question as to whether or not it always makes sense to do that. And very briefly, the reason that it's an open question is because if you have a PAGA lawsuit, there could be a class action. Like that's only for the penalty part of stuff, right? So say someone doesn't get their overtime. A PAGA lawsuit doesn't get, say someone's owed $20 for OT, right? That doesn't get that person the $20. It gets them a penalty for that $20 not being paid. You can bring a separate lawsuit or a class action to get those $20. That's why you'll see a class action, which goes for the underlying amounts that are owed, usually in conjunction with a PAGA lawsuit. They go hand in hand. Not always, but they do. So the cure remedies here oftentimes involve you as the employer admitting that you did something wrong to the plaintiff's attorney. And in my mind, even though that can't be used against you as a settlement communication directly, you're still telling the other side that, hey, I broke the law, and I get somewhat concerned about, well, wouldn't the plaintiff's attorney just use that for the class action side of things, and I'm still in trouble? So it depends on your circumstances. I'm not saying that you would never do it. It's just one of these reasons why when that PAGA process starts, reach out to someone who knows what they're talking about. So, if it's your HR consultant, hopefully it's your attorney, but at the end of the day, it should end up in the hands of an attorney to give you some advice about what you should do going forward. Next slide. Okay, so let's get away. That was the reform law, very high level. Like I said, when I did the presentation in the summer, it was 2 hours long. So what did I do up there in 10 minutes? There's a lot of detail there, but that's very high level. But take your reasonable steps down. Okay, so let's continue on with new laws that we actually got. So PAGA in the construction industry. So there is, for my unionized contractors out there are certain requirements, or there are certain things that are, if they're in your CBA, your collective bargaining agreement, if they're in there, you can get a PAGA exemption. So remember when I talked about like 130% of the minimum wage, that would be one of the requirements. But it's other things like having an express waiver of PAGA in your CBA. Trust me, your unions are going to know about this, and if they don't, you need to have that conversation with them. But regardless, there was this exemption that applied, and it was going to sunset basically on January 1st, 2025. So that got extended to 2038. So that's great. Point being is, if you are a unionized contractor out there, make sure that you have the PAGA language in there, because I've had PAGA lawsuits with unionized employers, and their CBAs just don't have the language. And I could have knocked out the entire thing just based on the language of the CBA, if the right language had been in there, and it just wasn't. So we had to go and actually litigate those things, and that was a lot of money that was spent that, with a little diligence and work with your union, didn't necessarily need to be so. All right, next slide. All right, so we will go on from wage and hour, and we will go to postings. So these are the things that, you may have an entire room wherever your headquarters are, that instead of having wallpaper or a lovely shade of white, has an entire wall or wallpaper of legal notices that go to your room. And they expand all the time. So I know a lot of you go out there and you will use the service that provides you with postings. Let's talk about a few new postings that are going into effect for 2025. So our current law is that employers have to keep in a location people are actually going to frequent a lot of notices. And one of them is, if they have a workers' comp issue, who you contact about that injury, the rights of the employee to select and change a treating doctor, and certain employee protections against discrimination. So now those postings under AB 1870 requires that notice also include information concerning the injured ability's ability to consult a licensed attorney. So you now have to advise employees, if they actually read this stuff, that they have the right to go to an attorney. Sometimes you get laws where it's like, I don't really know why this was necessary. Presumably this is something that people would have already known, but here we are. It's a posting amendment that's going to need to be changed. So if you haven't updated your postings in a while, this is one of those years to do it, because guess what? It's not just one posting, it's two. As we go to the next slide. This one involves whistleblower protections. So there's all these whistleblower protections that exist in California. Someone complains to you about some sort of illegal, condition. So, something's unsafe here. That's very common in your industry, but I'm not being paid right, whatever it might be. There's lots of whistleblower stuff that's out there. So currently the law requires that the employer to display a list of the employee's rights and responsibilities under these laws, which is pretty extensive. So AB 2299 requires the labor commissioner, so that's one of the arms of DIR, Department of Industrial Relations, to develop a model list of employees' rights and responsibilities. And the default is that when that thing is required, if you post it, you are deemed, or there's a presumption that you are deemed in compliance with that poster requirement for that particular law. So again, this is one of those things that when it comes online, you're going to want to update your postings and have this one in use. All right, next slide. Discrimination, harassment, retaliation. These are where the stories come, right? So I'm oftentimes asked, do I enjoy what I do? Quite honestly, if I was a real estate attorney, I don't know. But with employment law, it's the stories. And you get some really interesting stories and some fun stories sometimes after the fact, right? But it oftentimes comes from this. Now, I'm not downplaying any of this whatsoever. Sometimes it's just really horrendous situations and they're treated as such. But sometimes you get some very odd stories. And I don't know if I ever told the Naked Tuesday story, but someone person again remind me, I'll tell you, and I'll give you an example. But anyways, discrimination, harassment, retaliation. Let's go to the next slide. All right, so our main EEO law in California, which by the way, for the most part, California is always more protective than the federal. So I am usually always practicing with California law, not federal law. It happens, but usually California is more protective. Our main protective law for EEO purposes is called the Fair Employment and Housing Act, with the acronym being FEHA. And so this is where it does lots of things, but one of the things that it does is it's something that has that big laundry list of protected characteristics of things you can't do bad things to people because of those things. right? And this is the list that expands every year. So it's the stuff that you would usually think of, right? So race, sex, religion, disability, stuff like that. But it does grow over time, right? I mean, we got reproductive health decision-making 2 years ago. We got cannabis, although I know there's a carve-out for the construction trade, but it expands every year, right? So here's the issue. I know that I can't discriminate against someone because of their race. And I also know that I can't discriminate against someone because of their sex. What AB 1137 does is it says that you also can't discriminate against someone because of both of those things. This is one of those laws where it's like, I think I had that down. I think we got that, but the legislature didn't necessarily think so. So now it is very express that we have this list of things that we can't discriminate against people on, and now we can't do it because they have one of those characteristics or because they have more than one of those characteristics. So this is one of those laws that's going to require a change to your handbook. So if it's a handbook, usual normal handbook, it's going to have its own policy on EEO stuff. It's going to have a list of all the protected categories because you're required to under regulations that we got from the now Civil Rights Department in 2015. But this is going to be one of those things that you're going to need to change. The other thing that I want to point out is that, like I told you, I've been doing this presentation or versions of it since December. And as I was preparing for this, this particular presentation a couple of days ago, I realized that I have the wrong number on the block. So it's not SB 137, it's SB 1137. So that has been causing me to lose some sleep the last few nights because I had the concern, because I was doing this in December, the holiday season. So I know that when family members got around and they had listened to my presentation beforehand, you know, they gathered around, whatever it might be, for family dinner, maybe at the end of December, they're opening presents or something. I know that usually this presentation in the new laws is one of the things that family members often discuss, and it horrifies me that they may have been using the wrong Senate bill number. So as you go forward, because we do have a holiday coming up this weekend, when you're talking to your family members and close friends, make sure that you're using the right number, and you'll feel better about yourself, and I'll feel better about you as well. So next slide. SB 399. So this is a concept that comes from the National Labor Relations Act, talking about captive audiences. This is when employers get employees together, say this is a required meeting, and then they have some sort of presentation that they give. So it arose under federal law, under the NLRA, that's the National Labor Relations Act, to effectively prohibit employers from gathering people or employees together and then giving anti-union messages, right? So this is in that same sort of role, right? So, and by the way, you see Labor Code Section 1137 on its second bullet point, which is wrong. So don't ruin your holiday, make it SB 399. So that took effect on January 1st. It prohibits employers from requiring employees to attend meetings or listen to communications that involve the employer's political or religious views. Political, obviously, is a pretty broad concept. You know, like I said, these laws developed because of union messages, but it can be broader than that as well. So now you're prohibited from subjecting or threatening to basically retaliate or discriminate against an employee because they're not participating in those sorts of meetings. So you still are permitted to hold meetings to satisfy your legal requirements, such as safety meetings and harassment prevention training. And by the way, we are going into the new year, right? And that harassment prevention training is something that happens on a regular basis, right? So remember, this is a reminder that there's lots of trainings out there that have to be done on an annual basis for every 2 years. It's not just one and done, so be mindful of that. But that's our captive audience ban law. Next slide. Next slide, Julie.
Over to your end.
Improvise on this one. Okay, you're nuts. Oh, there we go. Driver's license and job applications. So the history of this one goes back to Ban the Box in 2017. That's a concept that arose out of LA that basically said that on job applications, you can't ask your applicants up front if they've ever been convicted of a felony, right? So from that, we have this very long process that you have to go through if that comes up. But what we have been seeing is that the legislature is taking jabs at other things that can be on job applications or not. So think about what was your old salary, things like that. So this is in that same vein. So this is about driver's licenses. So under this new law, you are prohibited from including statements about the need for a driver's license in job advertisements, postings, and applications. However, you're trying to get applicants, right? You can't talk about you need to have a driver's license. Now, there are an exception, and this is an and exception, so you need both of those things. One, you have to reasonably expect that driving to be one of the job functions of the position. And two, the employer has to also reasonably believe that using an alternative form of transportation would not be comparable in travel time or cost to the employer. So think of like using ride sharing is what this is hitting on most, but I guess it could be public transportation, something like that. So be mindful if you have one of those things that now there's a couple of requirements that you have to satisfy in order to have that requirement on a job application. So alternative form of transportation, it's defined in the law. Ride sharing, taxis, carpooling, bicycling, walking. So you got to consider those things. So put a little bit more thought into it. This is generally a reminder if you are using a copy and paste job application that you got online and you have no idea if it came from California or not, or someone who knows what they're talking about as far as it pertains to California law, you need to figure out if that's the case and get yourself a compliant job application. This is one of those things, if you get an attorney on your back, usually the first thing that they ask before they file a lawsuit is for the person's personal file. And this is going to be one of those things that are in there. And I've definitely had attorneys call my clients on the map because, hey, why are you asking about felonies? You can't do that. Why are you asking about salary that you got in your prior job? You generally can't do that. That's all potential class action stuff because it's common to everyone that's what that thing out. This is that same sort of thing. So make sure you got yourself a compliant job application. Next slide. Changes to employee leave. Okay, this is something else. All right, let's go to the next slide. The first one's somewhat easy if I remember right. So our next one is talking about, Julie, when you can change slides, it's talking about a vacation elimination for paid family leave. So paid family leave is a state benefit. So you'll see this, I mean, I encounter it most often when we have a pregnant employee, or one of my clients does. So usually how it usually works is that the employee will go off, if they have vacation, they'll use their vacation, but they usually qualify for 2 state benefit programs that the employer doesn't administer, but they're somewhat involved in it. The first one is for disability. And so that's usually before the birth happens. And then the next thing that kicks in is paid family leave. And so it's basically a wage, it's a percentage of a wage replacement for individuals that are qualifying. Usually I see it most of pregnancy, but it's disability, right? It's broader than that. It's paid family leave. So it involves family members as well. So it's a broader concept than that. But anyways, under current law, it authorizes employers to require that their workers use up to 2 weeks of their earned but unused vacation, PTO, whatever you want to call it. But if it's my opinion, use vacation, don't have PTO policies, that's another conversation. But anyways, you got this vacation, you got PTO that hasn't been used. Use the employer to require the employee to use 2 weeks of that prior to them then receiving the paid family leave benefits under the state. This law, which became effective this year, so AB 2123, eliminates the employer's ability to do that. So you be mindful, you're going to start getting paperwork if you've never dealt with this before. Your HR people, or whoever that is that deals with these sorts of issues, if you have an employee that's going out on leave, you're going to start getting those communications from the state. So it's just one of those things to be familiar with going into the future. But the state does provide you with a good amount of guidance as to how to go forward. All right, let's go to the one that I'm dreading. Next slide. All right. Okay. So as it exists now, you could take time off for jury duty and court appearances, or if you were a victim of a crime or abuse, right? So this is like in 3 different laws, and it was all in, this is one of those things that needs to be in your handbook, right? So what this law was doing, it was trying to consolidate those concepts and put it under jurisdiction of the California Civil Rights Department to come after employers on an administrative level. So it was trying to redirect what agency would be able to enforce this concept. But in the process, what it also ended up doing is it expanded the concept of, remember, getting leave for victims of crime or abuse. It changed that concept to qualifying actions of violence, which is going to get you. So that's defined. Qualifying actions of violence as domestic violence, sexual assault, stalking, and then an act which there's bodily injury or death to another. A firearm is somehow used in it, or perceived or actual threat. The qualifying act of violence is now applicable regardless of whether someone is actually arrested, prosecuted, or convicted of the crime. Right. So there doesn't necessarily need to be a court proceeding that is attached to that qualifying act of violence. It's the act of violence that matters, not what's happening in the criminal process. Next slide. Expanding off of that, if you're an employer with more than 25 employees, this law also extends protections to employees who have a family member, so not necessarily just themselves, but a family member that is a victim of a qualifying act of violence. Right, and it's trying to put it in track with FMLA, the Family and Medical Leave Act, or CFRA, the California Family Rights Act. So it's talking about a total amount of leave that can be taken as 12 weeks, 5 days for relocation purposes. There's a cap on that. And then again, the Civil Rights Department or division is taking over jurisdiction over it, enforcing this law on an administrative level, and they're going to be publishing some sort of notice about it. So we will be on the lookout for that. But this is one of those things that is going to require handbook changes. So because the concept should be already addressed in there, but you're going to have to change the language. Next slide. All right. So those were like the highlights of the new laws. And then we've got case law. So these are case decisions. So let's run them through pretty quickly. Let's go to the next slide. All right. So construction guys, talk to you a little bit about arbitration. I'm a very big fan of arbitration for employment disputes, and I'll tell you why in just a little bit. But California law requires employers in arbitration against employees to pay their share to the arbitrator within 30 days of the due date. So basically what ended up happening in this case, I'll just quickly summarize it. They were using a service called Chance, very popular arbitrator service, but the employer blew this deadline that was set by the law. And so what the court said is that when that 30-day deadline is blown by the employer has the ability to effectively invalidate the arbitration agreement and then go to court and proceed with their lawsuit. The law also requires employers to pay the employee's attorney's fee to get to that point in time. Now, this case is up on appeal to the California Supreme Court, so we'll see what happens there. But now I'm going to go into my thoughts and opinions on arbitration and why it makes sense if you're an employer to have it. So arbitration can do lots of things for employer-employee disputes. Obviously, you get in front of an arbitrator. Depending on the dispute, the thinking is on the employer's side of things that you have an arbitrator that typically is a retired judge or someone that's very seasoned in it, and they don't really get caught up in emotions. On the employer's side of things, there's a fear that juries sometimes do get caught up in emotions. So, and I have heard jurors where they say, well, we don't think the employer necessarily did something wrong, but we felt bad for the employee. So we felt like we had to do something for them, right? And that's very dangerous because, again, in California employment law, if the employee is getting 1 cent from the employer has to pay their attorney's fees for not only themselves, but for the employee as well. So that's one of the big upsides. But you can do other things with a well-drafted arbitration agreement. One of the biggest things is that you can have a class action waiver. So it says that the employee is only going to be able to bring a dispute against the employer in their individual capacity. They can't bring it as a class action, because a class action involves lots of different people. And these are the things where you can have classes, generally as low as 20 people, but you can have them in the thousands, right? And obviously, the more people that are involved, the more damages that are involved. So great thing about arbitration agreements is that you take the employee's ability to make it a class action away. The other thing that you can do is, and without getting into too much detail, is you can limit to a certain extent PAGA. So you can say the arbitrator is going to decide the employee's PAGA, individual PAGA claims, the things that actually affect them. And then in the court, it's going to stay the representative PAGA claims. These are the claims for the other employees as well. Plaintiffs' attorneys hate that because they want to get in, they want to get out, they want to get their payday. It's delaying that. So a good arbitration agreement can accomplish those sorts of things. So if you don't have them, I would highly recommend that you do and talk to someone who can help you in that process, getting one going forward. Only I knew any attorneys that actually did that. Anyways, next slide. Okay, so this one is talking about basically the concept of it's not always as simple for you construction folks that you start paying people when they clock in and you stop paying them when they clock out. Your obligation to pay is contingent upon whether or not you have control over that employee and what they're doing in their time. So you have seen over the past few years cases that I have presented to you. Starbucks was one of them. We got one, I think it was from IBM, where it's all these concepts, right? It's where someone's clocked out, but they're still kind of doing work, or they're required to do work, right? So like in the Starbucks case, it was the baristas, they had clocked out, but they actually had to walk from the till to the out. These are the people that are closing. They had to walk from the till to the door, walk out the door, and lock the door. So what is that, like 15, 20 seconds? Yeah, it's also compensable, right? You've got to pay for that because you're still under their control. So this is yet another case that is expanding on this concept and giving you some more examples. So in this particular case, we have this employer that had a security gate that you had to clear, and then you had to drive 15 minutes from there to get to the parking lot, and now you're actually at the job site where you would actually be clocking in generally and starting your work, right? So it could sometimes take 30 minutes to go through that process of just getting cleared through the security gate. So the California Supreme Court was deciding for these different chunks of time, was that compensable or not? So they determined that the time spent that the employees were going through the security clearance process, which is both at the end of the day and at the end of the day, that was something that the employer had to pay for because the employer was requiring that process actually happen. We got a very similar case with Apple several years ago, who have very expensive security checks for their employees that are working in the stores. So that time going through the security clearance had to be. However, the time that was spent after the security clearance and the 15-minute drive to the parking lot and then back at the end of the day didn't have to be paid, because the court said in those particular circumstances, it was very similar to any employee going to any workplace and having to find a parking spot when it's busy, or they have to get on an elevator. Maybe that's busy to get up to their office or whatever it might be. Regardless, the concept is it's not necessarily when they clock in and clock out when you have to pay. It can be more expensive than that, especially if you have traveling employees. So, and employees that are using their own car or maybe a company car to go to some sort of remote location for their work. So it's an expansive concept. In this case, only once again reminds us of that concept. Next slide. All right. We'll do this really fast. This is talking about pay stubs. So in this particular class action lawsuit, lots of things were being sought, but they were looking for pay stub penalties as well. And so the employer argued that it wasn't liable for penalties because there was a good faith mistake, or they had a good faith belief that they were providing compliant statements to their employees. But at the end of the day, that just wasn't the case. And the California Supreme Court sided with the employer and ruled that that potentially could be a defense. So, which is great. That's great news for employers. We're not getting a lot of wins out of the California Supreme Court nowadays, but that's great. But there's a lesson to be taken away from it, right? Again, remember all those reasonable steps for that PAGA reform bill? One of them is auditing your paperwork. And one of the things that you would audit is your pay stub. And this is one of those things that you're going to want to take a look at because it's so easy. I mean, I can take a look at a pay stub, and within about 30 seconds, I can go through the list of 9 in my head, and I can see if there's a problem. But just to give you an example of how expansive these lawsuits are and the theories that get thrown out, one of the requirements for a pay stub is that employees have their employee ID number on a pay stub. It was not my case, but it was a case that I was aware of, like the attorney that was doing it. This employer didn't use a number, meaning ABC, they used a letter. So it was employee ABC, right? And they got a class action lawsuit out of it because it's not an employee number, right? So that's something that if an employer, a diligent employer with some knowledge as to what those requirements were, just briefly looking at a pay stub, we could have taken care of that issue early on. And if you're not aware as to where you can find those requirements, just plug in pay stub requirements, California, and Labor Commissioner. So that will take you to the DLSE, the Division of Labor Standards Enforcement, and they have a nice section on their website that goes through a lot of these basic pay concepts, one of them being what needs to be on a All right. We've got one more slide. And it's talking about ways that you can listen to us more, and me in particular. So if you want to subscribe to the podcast, again, it is once a month. It is always less than 6 minutes because I don't want to lose your attention, and it takes a while to put this thing together. And I've got things to do on Sundays, right? So we keep it limited, but it is informative. And I just try to highlight something. Usually it's a new court case or something that came up or some broad concept. You know, when COVID happened, I was doing these weekly, and it was a lot of work because we got so many changes. But you have our contact information. You can email our friends over at Bender for that if you want to get on that list. And then we go to the next slide. The next slide is we're lawyers, so we have disclaimers, right? And that's our disclaimer. So read that, know it. And then we have one other slide, I think. Q&A. So no one asked any questions during my presentation, which is the first time I think that happened. But if you have questions for any of us, this is your opportunity to ask them. And if you don't have any questions, or do we?
All right. Well, we are definitely accepting questions in the Q&A section. I do have a couple questions for you, and I think that they're more for you, Aaron. Do any of these laws mean we need to update our handbooks? I think you mentioned one.
Yeah, there's two of them. So you're going to want to update your handbooks for the protected categories. You can't discriminate against two people or two characteristics. You're going to want to update your handbooks for the crime victims stuff. So that's another one. So those are the two that pop out at the top of my head. So, and again, this is handbook season to be doing those changes. It makes sense to do it at this point. All right. Do you have any others? Any others?
We do have one other. What protections, if any, can employers take for PAGA lawsuits?
Yeah, that arbitration agreements. Get your arbitration agreements. Like I said, you can get certain carve outs. It doesn't make PAGA go away.
Did you hear that question?
Yeah, I did. So it's arbitration agreement. So it doesn't make PAGA go away, but you definitely can limit it and get a little bit more control over the litigation, which is good. So,
Aaron, did you hear that last question that came through?
Yeah, I did. Are you not hearing me?
No, sorry. There was a little pause there.
Oh, no. Okay. Yeah, it's arbitration agreement. Put in arbitration agreement.
Yeah.
That's one of the protections you can do for PAGA. And of course, having compliant policies, of course. Any other questions on your end?
No, but I do want to share that if folks do have questions that pop up, please feel free to send them to us so we can connect with you.
Yeah, and they get to us, and we're more than happy to do that. So, all right, if there's no other questions, then we're going to wrap this up for 2024, going into 2025. As always, we appreciate your time, and we hope that this was educational and informative. So, on behalf of my friends and my partners over at Construction, and myself, thank you, and we'll do the Beverly Hillbillies wave goodbye and say see you later. Have a nice day, everyone. Thank you.
Thank you so much, Murphy Austin team. Have a wonderful day.
6 minutes. Hey, can I ask you a question? This is happening while you guys do it.